In this Supreme Court, containing 3 Trump appointees, 2 George W. Bush appointees, and 1 George H.W. Bush appointee, big business is winning big time. The financial backers of the Republican Party are getting exactly what they paid for. West Virginia versus EPA is the latest battle pitting America's big businesses, in this case big oil, against the needs of average Americans. Writing for the majority today, Chief Justice John Roberts admitted that capping carbon dioxide emissions may be a sensible solution to the crisis of the day, but then came the kicker. It is not plausible that Congress gave EPA the authority to adopt on its own such a regulatory scheme. Not plausible? Congress enacted the Environmental Protection Act in 1970. As with all laws, Congress left it to an agency, an administrative agency, in this case the EPA, to decide how that act was to be implemented and applied. That's what regulations do. They implement laws. In passing laws to protect the public, Congress cannot possibly foresee all ways in which those laws might be implemented and all circumstances in which the public might need the protections such laws accord. For the Supreme Court to give itself the authority to say whether Congress intended to delegate this much regulatory authority to the EPA is truly a radical act. If Congress has been unhappy with decades of EPA regulation, Congress surely has the power to pull that authority back. But it has not. As Justice Elena Kagan, writing for the dissenters, said, the court appoints itself, instead of Congress or the expert agency, the decision maker on climate policy. I cannot think of many things more frightening. Those were her words. The implications of this ruling extend all administrative agencies in the federal government to the Securities and Exchange Commission, implementing the Securities and Exchange Acts of 1933 and 1934, to the Federal Trade Commission, applying the Federal Trade Commission Act of 1914, to the Department of Labor, implementing the Fair Labor Standards Act of 1938, and so on, across the entire range of government and the entire range of regulations designed to protect consumers, investors, workers, and the environment. Starting today, all federal regulations will be under a cloud of uncertainty and potential litigation. A final implication of today's ruling is that the filibuster has to go. If the Supreme Court is going to require that Congress be more active and specific in protecting the environment or anything else, such a goal is implausible when 60 senators are necessary to enact it. Senate Democrats now have it in their power to abolish the filibuster. Well, today's case should convince them they must.